May I please, Your Honor? My lord, I beg to mention item number 5, my lord. Kindly pass over for the day, my lord. My lord, my senior is out of station due to serious illness of his family member,
Who is your senior?
Mr. N. Hock, my lord.
Okay, we'll pass the order when the matter is reached. Okay, not.
Most obliged.
May please, Your Lordship. I beg to mention for listing in a writ petition related to the foreigners matter, my lord. Matter was listed earlier also, my lord. Interpreter won't know after receive the LCR, my lord. The LCR is received, my lord. So, my lord, listed on.
Number? No, not to be retrieved. 24th.
24. Obliged.
May I please, Lordship? I beg to mention for listing of a writ petition pertaining to foreigners matter, Lordship. It was last listed on 24/7/2024. So, if I am praying for listing, Lordship, so can it be on next week?
For orders on 24th.
Of motion,
What order was passed on last occasion?
it was adjourned, Lordship. Obliged.
May it please Lordship, I beg to mention item number 6. This matter may be adjourned for the day, Lordship. My senior is out of station due to some personal difficulties.
Let the matter reach.
Master, please.
May I please to Lordship? I beg to mention number 1, may be pass over for the day.
Let the matter reach. Wait for some time.
Then we'll wait. We are item 13 to 61, that APSC matter, Lordship. There's a report of the SIT that we'll have to give Lordship in sealed cover. But if Lordship wishes to take it at turn, we would, because the main issue is going to be placing that report before Lordship in a sealed cover.
So now,
Report is done. We have the.
you have the report.
Yes, sir.
We'll take. Let us see the report, then we'll pass the order.
Also, one more thing, if I may just to assist, is if Lordship, if I may mention, we are in the report also, it's mentioned, but what is happening with some of the people when the departmental inquiries have been passed, it's mentioned in the report, they are seeking stay and stays are being issued also. So I just thought I'll bring it as a measure of information, no other thing we passed. And one item is a little different, which is the last item, item 61.
Right.
Item 61, he is now convicted in the other case, the Bhangagarh case, where the conviction has happened against a number of people. So item 61 is convicted. So I don't know if that would survive and would not become infructuous and continue with this appeal. But if Lordship wishes to hear on anything on that to assist Lordship, I'll wait till item 13 and then 10. Deeply obliged. We'll wait.
Wait for a few minutes, we'll take.
I will, of course. I'm grateful, Lordship.
Item number 1.
Item number 1.
1.
Let the matter reach.
Report. Sir. You place it always. I have a copy.
It is also yes, but it is in
But I have a copy. I feel stuck.
I have.
Oh, no. वो ये था क्या होगा रिपोर्ट देगा नहीं
রিপোর্ট তো দিলে নি
মেনশন করে দিলে আপডেট করে
আচ্ছা
Report sealed cover में
আগে এখন করাই নাই। না
রেগুলেশন 6 কি ভাই আমি দেখি পাইছো নি
কি বলিছে কি বলিছে
ফটো অর্ডার কি রিপোর্ট দিবলে
লাস্ট অর্ডার কপি তো আছে না আগর তো আছে তো Right. মই তাতে যাওঁ ইয়াতে একো হেৰি নাই যে। বুজিছা? মই তাতে
Just tell us,
Lordship.
page number 15 of the report.
Yes, Lordship.
In the second paragraph, there are names of two persons. Now, what are the materials available against those two persons?
Lordship.
What are the materials available against those two persons?
So Lordship, as Lordship has seen, basically,
No, against those two persons. There are two persons named there.
yes, Lordship, I know that. I can see that. So basically, Lordship, there are two.
Against others, you have given the report.
So therefore, Lordship, just for a moment, I'll just sum it up in a moment. These 9 pages was the original matter which came up before the learned code. Now, Lordship, everything comes up on page number 3. If Lordship would come to page number 3 for a minute. That table is there, Lordship. And Lordship, you will note that serial number 1 and 2 is the subject names on page number 15.
That's right.
Right, Lordship? And this deals to the 2013 examination. And Lordship may read the paragraph preceding that. Para 8. Is there? I'm not reading it. No. The second sentence points out what is the issue.
One request is being made. My lord, it is on a sealed cover, it will be produced before the court, and accordingly it has been produced. Now, we don't know what is the submission, because I'll just tell your lordship why this happened. Why this particular SIT was constituted by them. I argued the matter before the earlier division bench. And in that case, we have pointed out that there is on the basis of police report, you can discharge it. Apparently, there is no doubt about it. But this police report is a tainted police report. And we demonstrate before the court regarding about a 9-page tabulation sheet. How this investigation was carried on. How they kept 1,000 days with them before the trial court, and it was never produced. It went to FSL after 1,000 days. Even those persons were never charged sheeted. This is our basically case. That is why the court has asked my learned friend, what do you want to say on this aspect of the matter? 4 points was formulated. Now, thereafter, they came up before the court and said, we have already formed an SIT, which will investigate the matter. Now, I have been told, after the formation of the SIT, they have one investigating officer, other investigating officer gone. Now, they submitted, few of the candidates were picked up and they have filed one charge sheet before the trial court. Three. The court was not happy with that investigating officer. He was removed. Another particular investigating officer came out of them. So these are what, my lord, was happening. I don't know, my lord, what is there on record which was produced. At least, my lord, one request is being made. So at least we should also know now it is before this court.
3 charge sheets have been filed. Today they are passing an order on that also. Lordship, in any case, just to take off from where the learned senior said, my colleague. Essentially, Lordship, they had a problem with, they said, the loose tabulated sheet. That stands answered on page 14. Now, my learned friend cannot turn around and say that an investigation that should have happened against ABC beyond the people who are before this court, because of it not happening there, I should be discharged out of this entire proceeding. That is not there. Second, let us for a moment revisit the entire scam. What is the crux of the scam? The crux of the scam is that there is a massive, colossal fraud taking place in appointment to public offices. From the chairperson onwards, 2 FIRs are filed. Dibrugarh, Bhangagarh. As we stand today, the Bhangagarh FIR has resulted in a conviction. The sentencing of 4 years rigorous imprisonment has been passed, starting from the chairperson down to additional number of people who are named there. The second one, charge sheets have been filed up to a stage 11. 12, 13, 14 have subsequently been filed based on the SIT. It has widened the net. We must not forget that there were reports also being prepared by a commission, which was looking at all the material. What has come before the SIT has been looking at everything done so far. Additionally, what is there, that is brought before Lordship. Now, my friend can't claim to say that something that the court has asked for its information, which has come in a sealed cover, they should have a privity to that. They need to stand on their own legs on what is their case. And Lordship, I would respectfully say 3 things. The first being, where we stand today, the investigation is continuing exactly as it should have. And even those queries that were asked by the court are duly answered in this time's report. There were 4 concerns that the court said. I would respectfully say those 4 concerns stand fully answered. That there is no malafide in the investigation carried up to that point. Further investigation has brought a number of people into the net. Action is being taken against them. And none of these things pertain to staying of the investigation. Ultimately, my learned friend and his clients, they are all before here in appeal to the single judge upholding their discharge from service. So therefore, these are 2 separate things. And they were probationers. They had no vested right to say that they could have and should have got the benefit of a departmental inquiry prior to their discharge, because their entry was not bona fide. The entry was at the point of entry, the taint takes place. They can't claim that the rules of service which will apply for a bona fide entry into the service will apply to someone who has got into service in a tainted manner. That's the crux of the case. Now, my respectful submission, therefore, Lordship, would be threefold. First, the SIT has done its job. Should Lordship want an update also on the next date, we will file another report. We have no hesitation to do so. But I would respectfully say the queries stand answered. The SIT is doing it. This case is fit for hearing too. And if my Lordship wishes, 2 days can be fixed. We can argue the case on merits, which is the appeal. One particular case I would like to single out, which is item number 61. 61 is convicted. So his appeal, as far as I would say respectfully, is infructuous. So it has to move out of the bundle completely.
Lord, I'm sorry to trouble my. We don't know what is my learned friend 61. My lord, I think.
Item
They
61.
don't know whatever mail. It's now before the court. It was seal cover. Am I not entitled to look into their particular what stand they have taken?
I would just correct for the
Then-
record. I am not relying on anything in the sealed cover
But,
for item number 61.
Well, I
Item
think-
61, 1 minute, I'll just finish it,
Yes.
Lord. Item 61 is about a certain candidate who's in appeal here. He stands convicted now in the Bhangagad case. So I'm only saying that order can be placed before Lordship whenever Lordship wishes. It's a statement of fact. The learned counsel can certainly tell the court and assist the court whether he is convicted or not in the other case. That's the only thing to be answered.
But so far as, yes.
Please take your seat.
Service condition or discharge के बारे में
Hearing because we should take up the matter.
Yes, Lord. So, if Lordship would give me a moment. So if for hearing, if Lordship, I just as a request, maybe just after the vacations and fix 2 days at a stretch, then I'll be here to assist Lordship at a stretch. I'm told, I think October, most of the month, the court will be shut.
In the meantime, they can furnish the report before the court.
The report will be done. Next
Yes.
Tuesday, report is being submitted. That
But
is,
your lordships, what your lordship Honorable Justice Saikya has indicated, what was on that day, the past, that has to be looked into it. That's what.
Indicate.
No, that's what,
We're discussing.
my lord, when your lordship discussed,
Mr. Das, nothing was
my
indicated.
lord, what indicated to Honorable Justice Patel. Normally, I have been taught that whenever the judges discuss among themselves, you have to be very careful and listen. What discuss? This is one of our great senior lawyer who is no more.
Thing is this,
Yes.
difficulties, Mr. Kohli, with regard to that, what we have found from the para 8 and para 14, where the last piece 15, where you can see that the process has been installed with regard to the materials. We'll see here that issue also. Same thing.
in that also, Lordship, we were just speaking while Lordship was producing the report. I will be talking to the department. Perhaps we may, 2 things we would do is, one is bring before Lordship just for item 61, the conviction judgment, because it's not on
That
record.
is required to be placed.
Yes.
On the next date, you can place it.
And on this also, I'm going to speak to the department if we wish to file an IA specifically on that. And let's see what happens with that. That's due process. We have to follow that. So I was going to only request for Lordship's indulgence for hearing the matter sometime in November. And if Lordship would be pleased to give 2 dates, we'll.
By the next date, you submit the report after having the signatures on the text, and on that day, we'll fix the date for hearing.
I'm so grateful. I'll be so grateful. I will. आगे वो भी जाना है on report record पे ले आना है छोटा सा.
Pursuant to the order of report. The red printing at Mr. D. Das, London Senior Counsel. May AC preferred. Mr. Borba, you are assisted by whom?
I am appearing in item number 15.
Doesn't matter. What you were assisted by whom?
Assisted by you, Shaikia, my lord. Why
Mr.
I
Das?
do this matter? Actually, my lord, I at some length, there is some clear factual distinction, my lord. My case will be basically, Garnet single judge, my lord, make certain sweeping observations where I don't belong.
Because at the time of hearing, we'll be hearing you by each item, right? It will have a different.
The courts and the reports, my lord,
Separately deal.
let us not be kept in the dark.
Yes, that's what I'm saying.
Mr. Das, you are assisted by?
Mr. S. Das.
Mr. Patwa, you are appearing for whom?
My lord, I am appearing in a few items, my lord. I am led by Mr. K. M. Chaudhary.
61 you are appearing.
61 also appearing in other matters.
So you come up with your instructions. That
Yes, yes.
whether you
Now,
want to proceed.
criminal appeal has been filed, the sentence has been suspended.
Conviction still.
Conviction is the one.
Prepare the material.
Visionary, I have filed for it.
You are appearing as senior advocate then?
Yes. Any additional advantages? Mr. Dipankar is there and Mr. Ankit Roy and Ms. Nimisha Menon. Ms. Nimisha Menon.
Execution, final affidavit and bring it on record.
That is-
Open matter. It's a public document now.
बारह तेरह उन्नीस में 11 12 13 लेकिन मुझे
Submit as an interim report.
नहीं क्या 12 से 15 10 नंबर से
Relating to the investigation of federal police station case number 9.
दूसरे में लेना वही 19 से 22 और अगले वीक में 26 से 29 अभी नवंबर
This report carries for both, only for the Dibrugarh matter? or-
Yes, Lordship. That's right, Lordship.
Because the Bhangagarh matter.
Bhangagarh is over.
Taken care of.
Yes, Lordship. In fact, that was also only agricultural development officers. This was the wider one with others.
Along with the reply to the whole query. May 34. And it's order dated 29. Or. Comparison of the basis they got today. We found that the report contains the signature of the chief of the SIT concerned. Last week. Without having the signature of the state authority, the remaining pages. As such, the report plays before the board today. They have returned to Mr. Kohli. Enabling him to resubmit. On the next page. In a seal book. List on. 24/09/202.
That date will come up for the sealed report with signatures and fixation of dates. I'm so grateful to Lordship Sindal.
My lord, the irony of the matter From 2016, still investigation is going on. How many charge sheet has been filed?
Lordship, even the Mitra case went on for 35 years.
And
We've done very well.
The investigation from 2016 still going on till today. And they said before the learned single judge that a word has been quoted from O Chakradhar, commands acceptance. Investigation was so fabulously done. See what has happened till today.
Respectfully, Lordship, the irony is,
Respect, I am saying, my lord.
with equal respect and irony is that people wanted to be
Yes.
in public office to serve the people after paying 10 lakhs to 50 lakhs bribe. Deeply obliged, Lordship.
Deeply obliged.
May I please?
Just tell us when did the proceeding appear before the Supreme Police Board of Dhubri? On which date he appeared?
Due to some medical emergency, my senior could not prepare.
We want to know from you. At least that information you should give it to us.
No idea, Lord.
When did the proceeding appear before the Supreme Police Board pursuant to the order of the court passed on 28th of August?
No idea, Lord.
Ask your senior and tell us, we'll assume the matter, no doubt. But you have to tell us.
Okay.
What's your good name?
M. Rahman.
Huh?
M. Rahman.
M?
Rahman.
You are M. Rahman.
M. Rahman.
You are appearing on whose behalf? You are appearing on whose behalf? Who is your senior?
And Ahmed. Mr. N. Ahmed.
List on 19th. Enabling the counsels for the petitioner to apprise the court as to when the petitioner slash proceedee, comma, namely Sahib Ali, alias Sahib Ali, appeared before the Superintendent of Police Border, Dhubri, in pursuance of the order of the court dated 28/08/2024, passed earlier in this process. On the same date, Mr. Z. Sharma, standing counsel from Department of Assam, shall also apprise as to whether the petition named above appeared before the SP within bracket P Dhubri, pursuant to the order dated 28/08/2024, or not. And if so, list upon.
Little Lordships. My lord, we have challenged the order that is page 59, my lord. Regarding this case, my lord, we have a story that the order was passed in December 2023, but appeal has been filed just 2 months back. Because, my lord, once she engaged, the petitioner was arrested by police, then only he came to know that my case has been dismissed. A lawyer was engaged in High Court, and she has been also made as a party by name, that is respondent number 8. And her conversations have been recorded by the petitioner's wife, and she has admitted everything that your case is okay. You come tomorrow with some money and you will get the order. But before that, when she told this, the person was arrested. So all these matters we have narrated.
What relief have you sought for against the
That, my lord, actually we have only simply said
respondent
page 18, my lord. That is, sorry, page 13, para 18.
So you have stated, but what relief have you sought for? Because you have made a respondent.
No, relief means, my lord, I have narrated my pathetic story before your
We
lordship.
are asking you that you have filed a writ petition against somebody with a prayer. So what is the prayer against that respondent?
Where is this, my lord? Actually, I was arrested. I was
You are
arrested.
going back to your story again. We have heard your story. We want to know, since you have made the
What
counsel a party,
I understand that, but
what relief?
I am in jail, my lord. So my wife is doing everything. Once I come out, then only.
I am asking you, which is the way to go to Dispur, and you
Yes,
are
that-
telling me the road to airport
Yes,
and road to
I understand
Kakuli.
that we have to go to Bar Council. That is true. But thing is this, my lord, I am inside.
You have not gone. So therefore,
No.
the story which you have.
No, I was
narrated
given
before
the
the-
impression that I have got a good order.
No.
That's why, my lord,
Whatever
you
it
lost.
may be, whatever recordings you may have got,
Yeah.
these are mere statements. Who will verify that? The authority before whom you should have gone, you did not go for whatever reason. We are not asking you to go. What we are saying is this story which you have made before us, according to us, prima facie is not relevant.
That's
So
why, my
you'll
lord,
have to
the other day
explain.
I prayed that
You'll
there
have
should
to
be camera
explain why
hearing
after
because
22
many other things are recorded.
But you are not there.
I do not want to
You have
disclose.
not even filed an FIR. Have you filed an FIR?
No.
Then, if this is such a is falsification of everything, asking you money, have you filed an FIR?
Thing is this, well, I am inside, that is the problem. When I came to know about the Mokari,
Who gave you the recordings and who gave you all these information?
no, this, her wife, his wife has given,
Then,
his wife is the affiant here.
Mr. Mahmood, you are a very seasoned counsel. You are a very seasoned counsel. You have done hundreds of cases. You have done more cases than both of us together in this subject matter.
Actually, my lord, we do not want so much thing to disclose at this point, but my prayer is only this, my lord. I have some papers which will prima facie satisfy that we have a good case. For instance, my lord, there is father's name in the voters list, and my name is there along with my father. And I voters ID card, PAN card with my
You
father.
tell us that some evidence was produced, it was not considered by the tribunal.
Exhibit.
You tell us that from the records that certain applications were filed, you were given liberty, but notwithstanding that, the court went on to pass an order. Point out something like that.
Here, my lord, the petitioner adduced his evidence.
Right.
And
You
also,
have produced 14 exhibit.
yes, so exhibits, so many exhibits. Some papers are in the hands of Rasuna number 8, but she did not return it.
Then
So, she did not return, but so what was available with her, through that papers only we have filed this petition. So for the timing, my lord, I have annexed certain documents. May I pray that I should be granted bail, my lord? Then I will take everything, my
you
lord.
know what bail? You are declared illegal immigrant. You are declared.
Yes, declare.
What under the law you can't go around.
No, when a declared foreigner may be also granted bail, there are so many instances.
There are instances, but in your case, we are not convinced that this is a case which calls for such an order at this stage.
We are
We
not
are
sure.
willing to give you an early hearing if you want. We are ready to take up the matter today and pull it off.
This matter is heard twice, my lord, earlier. Of course, my lord and Justice Surana was there.
I remember, therefore I am putting in the question.
Yes, yes. So,
On the last occasion, when we raised this question, you said you wanted some instruction from your client.
instruction
In
up to
respect
that
of that.
extent, my lord, immediately he was arrested. His wife came and said everything. What she said, we have written that. Not more than that. Now, story may be also different if I hear from the petitioner, because petitioner came to the lawyer. So, my lord, otherwise, my lord, we have annexed certain documents, 66 voter list of my grandfather. This is a voter list of my grandfather, and 71 voter list of my grandfather, 97 voter list of my father with my grandfather, and 2015 voter list, my name is there with my father, and PAN card, ID card, these are exhibited 9 and 11. There are the names of my father. So there are linkages, my lord. There are linkages, sufficient linkages are there. So in my opinion, my lord, your lordship be satisfied, case may be remanded back, my lord. My lord, may I see for a moment the LCR, my lord? LCR is there. May I see for a moment?
Mr. Sharma, have you gone through the LCR?
No, Lord.
I have not done it.
Why do you wait for the invitation? You should go through.
Lordship.
Why do you want
the court to invite you to examine the LCR, it is there, not this one.
Hmm?
Otherwise, lordship, here link between father and grandfather was not established, lordship. তিন নম্বৰটো লৈ আহক। Not there. Problem to जब बेल लगे हाँ जरूर আছে ওগুলো হেডি করেছিল কোনটি দিয়া নাই Mr. Mahmood, when the procedure was arrested,
My lord,
when the procedure was arrested,
he was arrested. 22/7/24. Case 13, para 18.
this July only.
Yes. I was given the impression that I have been already granted bail, everything is okay. That's why, my lord.
Who granted you bail?
No, these things are duly recorded, my lord. Of course, if your lordship hear the matter in camera, then I mean, this, many things are there. But our only prayer is this, my lord, rightly or wrongly, I have done something. So I may kindly be granted bail, my lord, so that I may take proper defense of my case. And the wife of the petitioner, she is having 3 minor children, so she is not in a position to run so much running.
Okay.
तीन नंबर দুটা হেডিং
Mr. Mahmood, the ordership reveals that only on very few occasions you remained absent during the proceeding. In most of the occasions you are present. You have submitted your some documents, certified copies of the voter list of your father and yourself. On 21st of November 2022, before the tribunal. And on 5th of December, you were present. You filed an self-shown affidavit correcting the name of your grandfather and everything. In your presence, the date for passing of the order was final order after hearing the arguments, everything was passed. Fixing 28th of December 2022, directing you to remain present at the time of delivery of the opinion. This order was of 5th of December 2022. You are aware that 28th of December 2022 is the date for opinion to be delivered by the tribunal in this case. On 28th of December 2022, you remain absent. And in spite of the order of the tribunal passed on the previous date on 5th of December 2022. And on 28th of 12, 2022, 28th December 20, we were declared as a foreigner. The opinion was delivered. And you were found to be a foreigner as you failed to place the relevant materials before the tribunal. Now, on 5th of December 2022, you are aware that 28/12/2022 is the date for the opinion. And C, have been arrested only on 22nd of July 2024. Thereafter, you have filed this writ petition challenging the order of 28th of December 2022. These are the records. Why should you consider you for bail? as brother suggested, we'll hear the matter.
My lord, actually, normally,
See, you are aware of on 5th of December 2022, because you have been regularly appointed. On few occasions, 3 to 5 occasions, you remain absent in the entire process. But all the dates you're present. So, on 5th of December 2022, we are also present when the date was fixed at 28th of December, the opinion will be issued. You on that day, it was directed that you should be present, but you did not prefer to be present. Maybe fearing that you will be declared as a foreigner, or maybe some reason. But you are aware what would happen. Only after your arrest on 22nd of July 2024, you have filed this. So even if you ask for bail at this stage, I think we should not consider it.
but,
That's what the
actually,
records we are saying. nothing else.
immediately after vacation, after declaration of foreigner, he came to the Honorable High Court and engaged respondent number 8 as his lawyer. But
See, basically, that kind of thing, since you have no claim against the respondent number 8, you have not paid anything. Such kind of things cannot be considered in this application. We are here only with regard to finding out whether the order of the tribunal issued on 28th of December 2022 is good or bad. That's all.
if your lordships do not consider that, even then, my lord, I have a case, if your lordships,
Consider in the time of.
no, because
want
my
that it
lord,
should be hard at
66
admission
voter
stage,
list
we can
is
hear
there.
it.
66 voter list in the name of my grandfather is there. And 71 voter list also in my grandfather, these are exhibited documents, these are. Then my father's name is with my grandfather, that is exhibit 3. And earlier was exhibit 1 and 2.
Hmm.
1 is the 66 voter list of my grandfather, 2 is 71 voter list of my grandfather. 3 is my voter list with my father,
With whom?
exhibit 3.
With whom?
With my grandfather, that is Zainuddin.
Hmm.
Can you see page 17 first?
No, we are on that. If you want to argue the matter, we will hear it. Exhibit 3, you are talking about which voter list?
It is the voter list of 1997.
Was it a certified copy?
Certificate copy. I think there is no dispute on this.
Hmm?
Because learned tribunal has written. Yes, it is my lord certified copy.
Hmm.
Certified copy means it is my lord, certified copy need not be written because it is computer generated voter list. Page 21.
It's a translated copy.
My lord.
It's a translated copy.
So it has been exhibited, my lord, without any objection.
Doesn't matter whether it has an evidentiary value
Yes. It
as
has,
per law.
yes. Yes, it has evidentiary value, my lord.
As per law,
Yes.
evidence says so.
Evidence says so, and also there are
Okay.
judgments of the Honorable Supreme Court also.
Hmm.
That is, my lord, downloaded copy of order obtained from internet is acceptable without any signature.
Hmm.
So it is 2018 SCC Online Bombay 206.
But this exhibit 3, 1997 voter list, right?
Yes. So there is leakage one.
Page number 21.
Yes, page 21. It's a voter list of
Right,
19.
exhibit 3.
Yes.
Then come to page number 22.
22. 20.
Down below.
Yes.
Yes.
This is true English translation of Assamese version of certified electoral roll.
Yes.
So how do you expect to be in evidence?
But I
It's
have,
an English translation of Assamese version. So translated copy,
no, but here,
downloaded.
what I can
The
say.
order of the Mumbai High Court with respectfully saying that it was a downloaded order of the court from the internet. Here is downloaded translated version.
Well,
So whether the evidence
here
exists-
I have little to say.
See,
But
you
how
have to
can-
tell us from evidence, not from anything else.
That is to secondary evidence, my lord.
Definitely, why not?
Yes.
But when?
And it is clearly mentioned digitally signed by,
Whatever, that is the reason we're asking you. Then what was the requirement of your submitting or certified copy later on? Why did you submit it as certified copy?
because
Why on subsequent dates? On 5th of December or in November, you have decided to submit the certified copy.
when one document is acceptable
What? That the reason
in
we're
law,
asking you,
why
Mr.
I will bring another one?
Mahmood, same document, why you have submitted as a certified copy? Why?
Well, it is the normal practice that
What was
digitally,
the requirement of submitting certified copy at a later stage? Same voter list?
here when it was submitted, it was duly exhibited without any objection from other side. And
That
there
is
is
not the
judgment
issue.
of the Supreme Court that any objection should be at the first instance. In High Court, I think that is not
This is
acceptable.
only basis of whatever evidence, because you have to lead the evidence. Not
No,
the
no,
state.
there is judgment of the Supreme Court. If
No.
there is any objection regarding the veracity of a document, that should be raised in the first stage.
We'll
Not,
look into it.
Lordship is aware about that.
So are you ready with the matter? We'll hear you. If you are ready.
Actually, my lord, I was on the expectation that I would be granted bail today.
You have shown, you are aware of the date, but you have not moved anything.
But what are
Only after
there?
filing of your arrest.
Any condition, well, I may be granted bail, then I will satisfy your lordship definitely on law point. But at least I have a privacy case to grant bail, madam.
No.
Because the documents which are exhibited, those prima facie satisfy that I am an Indian citizen. So,
Heard, Mr. M.U. Mahmood. Grant counsel for the petitioner. And Mr. G. Sharma, standing counsel, Home Department, Assam. Who is representing election?
Your Lordship, for response number 2, I'm appearing. I'm P. Barwaya, Election Commission of India.
MSP Gurwar, and no representation on behalf of just one number on, or MSP Borua. P.
P. Barwai.
Full name, ma'am?
Your Lordship, I'm Pallavi Barwa.
Okay, I have seen it. Okay, go. MSP Borua. BARUH or double O?
It's BARUA.
RUA.
Yes, no it.
It's a reconciliation. Mr. G. Sharma, the council home department is on for number 3, 6, 7. And Mr. P. Sharma, additional senior government officer. For the rest of the Five. Activity order. Activity judgment plus opinion. Dated 28/12/2022. Passed by learned member of Fairness Tribunal, First Mongol Road, Dorong. In case number F.T.1171/2012, corresponding to 432/2012, whereby he has been declared to be a foreigner plus illegal migrant who had entered into territory of India in the Assam honor after 25/03/1971. The petitioner has filed this petition on 02/08/2024. Pursuant to the order of the court, dated 07/08/2024, the registry has already received the record from the Fairness Tribunal, First Mongol Road, Dorong. The petitioner while praying to set aside and quash the impugn opinion dated 31/12/2022, passed by the landed Fairness Tribunal number 1 Mongol Road, Dorong in said FP case number 1171/2010, noted. Also pray for an interim order praying to suspend / stay the operation of the said impugn opinion dated 28/12/2022, passed by learned Fairness Tribunal number 1 Mongol Road. And also to direct the Superintendent of Police Border Dorong to release him from the detention camp of Dorong It is submitted by the petitioner that on on the night of 22/07/2024, he was taken into custody pursuant to the said opinion dated 28/12/2022, passed by the learned foreign staff first Mongol wrong in application number 117 of 2010, and since then he is in custody. On perusal of the records, it is seen that records of the state furnace. It is seen that on 05/12/2022, the petitioner was present before the tribunal and on the same date, the petitioner slash proceeding filed an affidavit along with certain copies of documents and he was duly cross-examined. The petitioner did not press for examination of the DW2, his own witness. On the said date itself, on 05/12/2022, arguments of both the parties were heard, and in presence of the petitioner, (28/12/2022) was fixed for delivery of the opinion, where the tribunal, by the said order dated 05/12/2022, directed the petitioner slash proceeding to remain present before the tribunal on 28/12/2022. However, on 28/12/2022, during the passing of the impugned judgment of slash opinion, the petitioner slash proceeding remain absent on the said date before the said trial. However, furthermore, the petitioner did not prefer any appeal, prefer any petition against the said impugned judgment slash opinion dated 28/12/2022. Till date of filing of this petition on 02/08/2024, after his detention in said application number 6. Though he was fully aware of the said proceeding being FT case number 1171 of 2012 against him was pending before the furnace tribunal first Mongoldori, Dorong, and that 28/12/2022 was the date fixed for delivery of the opinion in the said proceeding by the concerned furnace tribunal. Considering the above, we are of the opinion that it is not a fit case to grant bail to the petitioner slash proceeding, who is in detention since the night of 22 days. Personally impugn the slash opinion 28/12/2022. Understand? Around in interim pair of the petition. As it is also seen from this petition that the petitioner is not petitioner slash person, not claiming any relief against the respondent number 8. In view of the above, decided not to issue any notice, which was also considered earlier by the court on 28/08 by order. This petition be admitted for hearing. Registry sir, place this matter for hearing.
My lord, item 12. Item 12 may kindly be taken after vacation, my lord. Many juniors have not come, so there is some problem. my lord.
I have the counsel for the petitioner, Mr. Renu. This review petition is adjourned for 6 weeks. Registry shall use this matter thereafter.
Obliged.
Surya Chitawat. Interim order of creation. Ceremony. Representation on behalf of the petitioner on call. So names of two learned counsels for the petitioner as reflected in the process. Since September 2017, the petitioner is on interim protection. So by order, by the impugn order, that's opinion dated 17/12/2016, the petitioner was declared to be a foreigner. Were illegally entered into the territory of India within the Assam on or after 25/039. It is seen that even on last occasion, i.e. on 13/08/2024, the petitioner remained unprepared. Hard Mr. Z. Sharma, standing counsel. Sorry. K. Gogoi, standing counsel. Lanet CGC for respondent number. Z. Sharma, standing counsel, Home Department for respondent number 2 and Mr. P. Sharma. Lanet, additional senior government Assam for respondent number 3. Pursuant to the order dated 06/09/2017, the registry already received the records of the 11 records from the Foreigners Tribunal number 5th. Further, in pursuance of the order dated 13/08/2024, the registry has also received the records of review case number 3/17. It said in the FP case number, in the concern FP case number, in the concern FP case from Foreigners Tribunal 5th, Walper, list on 24. Order of the Tribunal 2010. prefer to read petition, hey, তোমার NRC ক্ষমতা হয় না, নাম নাই, এখানে 2017 পর। মকর দেশ থাকো, এই নেই, 2000 কি করে? No representation on behalf of the petitioner on call. Though names of 4 councils for him has been reflected in the document. Are Mr. K. Gogoi, Planet CGC, Mr. J. Pang, Standing Consultant Department for the responding by 2, 4 and 5, and Mr. P. Sharma, Additional Cinema for 3. By an order dated 22/02/2010, passed by the London Foreigners Tribunal, Dibrugarh, in case number FT 370/2006, arising out of P.E. number 682/2002, opined the petitioner to be a foreigner of post 25/03/1971. Agree with the said opinion / order dated 22/02/2010 noted above, and further, that the petitioner, Mr. K. Gogoi, Planet CGC, Responding by 2, 4 and 5, and Mr. P. Sharma, Additional Cinema for 3, agree with the said opinion / order dated 22/02/2010 noted above, Don't write it. The petitioner filed this writ petition on 18/12/2017. Notice in this case was issued on 29/01/2018. It is stated by the petitioner in this petition that he was arrested on 08/06/2017. And the court, by its order dated 29/01/2018, while issuing notice in the interim, directed not to deport the petitioner from India until further orders. But did not grant him bail. Regis A has also received the relevant records from the Foreigners Tribunal, Kolkata, Dibrugarh. That was called for by order dated 29/01. Let's stop. 24th.
May I please, Your Honor? My lord,
May I mention
yes, my lord.
just a on the prayer of Mr. M. Hussain, counsel for the petitioner. Matter be adjourned today and list for hearing on 26th. Impugn opinion is of October 2017. And the petitioner is on interim since February 2018. No further adjournments are granted to the petition.
Most obliged.
May I please, Lordship? This matter may pass over for the day, Lordship.
Or
For the day.
why?
Our senior is out of station.
Who is your senior?
A.M. Ahmed.
A.M. Ahmed.
Yes, Your Lordship.
His name is not here.
A.M. Ahmed, Lordship.
Do you know his full name?
Abdul Motin Ahmed.
But there are other counsel.
Yes, Lordship.
Senior counsel
Nobody
H.R.
is
Chaudhary is
present
there, Mr.
today.
I. Hazarika is there, Mr. H. Ahmed. Mrs. H. Amir. What's your good name?
Bidas.
Are you aware of the case?
Lordship,
What is the facts in it?
little bit, not more.
What happened?
Lordship, Lordship, the petitioner was moved to Dipti village to Bamuni Bari at the age of
Why the tribunal did not consider the case of the petitioner to be an Indian citizen? Why his case he was considered to be a foreigner?
because Lordship, his father appears in voter list of 1960. Okay. 1966, but his father's village is different from the petitioner.
How the proceeding could prove his link with his parents or grandparents who lived in India prior to 25th of March 1970? How could the proceeding could prove?
Lordship,
What was his link
in
document?
DW2, Gaon Burha certificate, page number. Lordship, in page number 33, Gaon Burha certificate, he stated that the petitioner was shifted from the village Dipti to Bamuni Bari till more than 30 years ago. That's the reason, Lordship, his father's village and the petitioner village are different.
Under which provision the Gambura can issue the certificate? Are you aware? Under which provision a Gambura is appointed? What is his duty? Now, the concerned Gambura who have issued this certificate on 2nd of June 2017, or this is exhibit 10, right?
Yes.
It was issued on 14th of May 2007, 14th of August 2017. Whether he adduced evidence evidence, come to page number 52.
Yes.
Have you read page 52? Now come to the cross. Page 52.
Page 5. Please.
Got the page number 52.
Yes, Your Lordship.
Read the cross.
Um, I know P. Muhammad
No, no, that is the chief,
Shaif, yes, yeah.
the cross part. Same page,
Okay.
down below.
Muhammad Ali is not reside in my last
Lot.
lot. I issued the certificate on the verbal request of Muhammad Ali. Muhammad Ali did not go to school. He was there at the age of 15 years. Nawab Ali expired about 15-16 years ago. Late Shahiba Bibi was mother of Muhammad Ali. She expired during my childhood before I got earlier of the tech. I became Gaumburha in August 2005.
So whatever information he has been given before the court or whatever the certificate he has given was on the verbal request of the proceeding, and whatever he has stated, it is his personal knowledge. Right? As a Gaumburha, he cannot say as a parent, he is a Gaumburha of different village, not in the village where the petitioner or the proceeding resides. So his personal knowledge will not help.
Lordship, there is two Gaumburha certificate.
Near
Page number
53.
53, yes, Lordship.
Another certificate is at page 35, right?
Yes, Lordship.
Okay. Yes. Now can you read page 35?
Page 34,
35.
35.
Can you read Assamese?
Yes.
Read.
প্ৰমাণপত্ৰ দিয়া হ'ল যে নলবাৰী জিলা টিহু থানাৰ নমাটি মৌজাৰ অন্তৰ্গত বামুণীবাৰী গাঁৱৰ বাসিন্দা শ্ৰী মহম্মদ আলী পিতা নবাব আলী এওঁলোকে বামুণীবাৰী গাঁৱত বসবাস কৰি আছে মই জানো মহম্মদ আলী অনু মালিক ৩০ বছৰ বয়স ধৰি বামুণীবাৰী গাঁৱত স্থায়ীভাৱে বসবাস কৰি আছে মই ভালদৰে জানো
Now please come to page number 53.
Yes, Lord.
Read the cross.
I am a Gaumburha of village Bamunibari since 2008. I issued a certificate on verbal request of Muhammad Ali. True, I have written as permanent resident, but I have not got any instruction of notification for writing as about. I am not sure whether I can give any permanent residence certificate. I have not gone to any document relating to Muhammad Ali. I wrote his father's name on the basis of the information given by Muhammad Ali. I have stated keeping the record of the villagers since 2009. I was updated about 1 month ago.
So is it reliable? Here it is only this particular certificate relates to the resident of the proceeding. How to indicate that his father was in India at that point of time? Or how, what is the link document of the proceeding with his father or grandfather or his parent or grandparent? To prove his citizenship in India.
Lordship, kindly say DW4, page number 54. Tayez Ali, the petitioner was there.
Was serving
As
in
a-
his house, right?
Yes, as a servant for 30 years.
If somebody is here for 30 years in India, Will it amount to that he's a citizen of India?
No, not yet.
He has to show he was there prior to 25/3/71. Or his parent, or his grandparent. That link has to be there.
A good junior is one who can paralyze his or her senior.
Lordship,
Got it?
Lordship,
So we
may
have
kindly
junior.
fix a date, senior will appear.
What's your good name?
Vidas.
Does this matter for hearing? Again on 25.
Master Bless.
24.
Kindly adjourn for today, Lordship.
Why?
Lordship, Mr. B. Sinha will appear, Lordship. He is not well,
Give a
Lordship.
try.
Lordship,
If the case is that will not dismiss, give a try. You are Mr.
yeah, Hussain, Lordship.
M. Hussain.
Yeah, Hussain.
So you are the petitioner counsel.
Yes, Lordship.
What is the difficulty?
Lordship, we will argue, Lordship.
Who will argue?
B. Sinha, Lordship.
B. Sinha will argue. Case is yours.
No, no, Lordship. His case, Lordship.
Your name is there in Okalatnama. You should argue.
Yes, Lordship.
Will not adjourn.
Some other day, Lordship, kindly.
Why? Why?
B. Sinha will appear, Lordship. And fixed on next week, Lordship. On Lordship.
They are giving in next week. With the request of Mr. M. Hussain.
Yes.
Who submits that the arguing counsel, Mr. D. Sinha. That paper to be listed next week. On a date to be fixed by the registrar. Mr. D. Sharma, Mr. Lee, and anyone else? Mr. Talukdar. Here's for.
Yes.
May plead, your Lordship. Lordship, in this case, Lordship petitioner declare foreigner 66 to 71 stream money. And the tribunal directed to me to appear before the district magistrate and they state our name, my lord. We comply the order of the tribunal, my lord, but the district magistrate said we are not competent authority. We go to the competent authority. Then after we appear before the FRRO, my lord, the FRRO is not accepted because, my lord, direction was not given to FRRO. That is the case, my lord. Humble submission, humble prayer is that, my lord. I want to register my name before the competent authority, my lord.
Mr. Sharma, is it FRRO district magistrate?
Concern SP lordship.
Hmm?
Concern SP lord.
Prior to that, because concern NP has been considered to be the FRRO at a later stage.
Yes, lordship.
But during the time when the order was passed,
Yes, yes,
was-
lordship.
that point in time there is a specific FRRO.
2016.
2016. Let me take the instruction, Lordship, next Tuesday, Lordship, I will put it. Yeah, for the morning. Recently. For the morning.
না বন্ধ করে প্রথম order ছিল।
FRO is a competent authority.
প্রথম কথা
এটা আপনি edit modification
preference is up to 20 minutes but
modification কাৰণে আপোনাৰ সেইটো কৰিলে হৈ যাব
notice কোন
Remote vehicle foreigner declaration. Now in third stage district magistrate total rules commission authority FRO accept নকৰে যিহেতু physically FRO Okay. এইবিলাক এক্সিবিটৰ ওপৰত থাকে থাকে ৰিমট ভেৰিফাই কৰি লওঁ কৰি
No, the Patna is notice. Proposals given between 1 to Where is the notice?
Notice my lord, next my lord. Will not the next my lord. No, answer is there, my lord. Not to be answer, my lord. No, humble submission, I want to comply this order, my lord. I want to comply this order.
You can comply provided the order is correct, but you have to examine that also.
Actually, it is, we appeared before the district magistrate. District magistrate denied.
To get the notice.
Notice,
It is not enforced.
my lord.
There was a notice issued to you.
Notice issue against me, my lord, but notice is not available in my hand. My lord.
Payang, Mr. Sharma.
What?
Go to the record and tell us. Mr. Hassan says he'll comply with the order.
No.
We have not annexed any documents.
Not my lord. Only one document, my lord, to representation, my lord. Annexed to my lord. The district foreigner regional officer Sunitpur, my lord. 4117.
So on what basis you will make your argument,
My lord, only this is my lord, opinion, my lord.
opinion?
Yes, my lord.
Okay. Where is your written statement?
Don't relate to this.
Come to page number 10.
Yes, my lord.
Read the third paragraph in his written statement.
In his written statement, the OP has stated that he was born in Kalakuchi village under Misamari police station in district Sonitpur of Assam. The name of OP's father is late Abdul Rahman. OP grandfather's name is late Asanullah alias Asan, and he resides at village Ulubari PS, Lahoriga district, Nagaon, Assam. My lord. Then after the exhibit number 1 is the electoral roll of 1970 office grandfather, namely Asaullah alias Hassan of his grandfather is enlisted in 84 Lahorigarh LAC at the place Ulubari PS Lahorigarh district Nagaon Assam by part number census. Exhibit 2 is the electoral roll of 1979 wherein the name of the office father Abdul Rahman is enlisted in 83 Dehing LAC at the village Cholmari PS Lahorigarh district Nagaon Assam by part number 73 serial number 58 house number 30. Office father named Abdul Rahman is also enlisted in this same list by its serial number 71. In Exhibit 3, OP has submitted the electoral photo ID card of his own name, Abdul Mateen, issued by the Election Commission of India. The name of office, father late Abdul Rahman, and addresses are mentioned in this card. Exhibit 4 is a Gavura certificate issued by the Gavura of village Kalakusi. The certificate identifies Mr. Abdul Mateen to be son of late Abdul Rahman, an inhabitant of Kalakusi village under Misamiri police station in district Sonitpur, Assam. I have examined the proceeding MD Abdul Mateen and proceedings younger brother Shafiqul Islam as witnesses of the reference, and the learned counsel appearing for the OP in his written statement, para number 5, stated that he is a citizen of India by birth and he was born and brought up at India soil. I at village Kalakusi, PS Misamiri district Sonitpur, Assam. But OP witnesses at evidence states MD Abdul Mateen stated that he was born and brought up at village Solamari, PS Lahorigarh district, Nagaon, Assam. Perusing the entire material on record as well as document relied upon by the OP, as discussed above, this tribunal arrives at the opinion that the proceeding, namely Abdul Mateen, son of late Abdul Rahman, residing of village Lokhabora, PS Misamari district, Sonitpur, Assam, is a foreigner. That proceeding, namely MD Abdul Mateen, son of late Abdul Rahman, residing in village Lokhabora, PS Misamiri district, Sonitpur, Assam, entered into India between 1/1/1966 to 24/3/1971, and he is directed to register herself in accordance with Rule 19 of the Citizenship Rules 2009 before the competent authority district magistrate within 30 days from the order hereof. The name of the proceeding be struck off from the electoral rules in period of 10 years. My lord, it is typically, my lord, wrong, my lord, most probably. It is not a district magistrate, it is a FRRO.
Where from you can show that you are the stream from 1966 to 1970.
The tribunal finding, my lord. It is a finding of the tribunal, my lord.
Yes, Home Department. You will come back at to go to the records and tell us what to do.
One for the record.
Go to the records, from the records.
Yes.
Petitioner did not annex anything. You have to make
Yes.
it public.
May I please, your lordship?
Yes,
My lord, I beg to mention item number 10, my lord.
holiday
My lord,
mood. Or festival mood, festive mood.
some personal difficulties, my
Okay.
lord, today.
Which item?
Next week, my lord.
Which item?
Item number 10, my lord.
Okay, Mr.
Yes.
Yes, ma'am.
Lordship, similar prayer in item number 11, Lordship.
11,
Yes,
all after vacation.
any date, Lordship, day after tomorrow also, but today I have had some difficulty.
Okay, let us see. We'll have it after vacation.
Oblate,
Some matters are fixed, that's the reason.
after vacation.
That's hello for my.
My lord, I have gone through the record, my lord. From the record, it reveals, my lord.
See, three things we have noticed there.
Yes,
That the projected grandfather's voter list,
70,
sometimes of 1971 probably,
70.
70. Right. And that is from a different constituency.
Different villages.
Then in the 79 voter list of his projected father,
Right.
he
It's
is from again from a different constituency, different village.
Yes,
And subsequently, the petitioner's voter list, which is of a different district altogether,
not
that is not
it is-
different. This
it's
is
voter ID. Voter ID of the
voter
petition.
ID. That is from a different district.
Different village.
Different district. Now, only the petitioner's projected brother, of course, I have not gone through the records with
Yes.
the written statement. But one brother said they are the own parental brother and they are staying somewhere in the place of his father. So how you have connected, how the petitioner connected his link with his projected father and grandfather?
That is not there. That is not there. And
But this is an writ petition filed by the petitioner, the proceeding.
no, my lord, the term here, my lord, what my submission would be, my lord, the inquiry report from number 1.
That we have seen.
Yes.
That is, he is found to be after 25/03/1971. And
Similarly, my lord, the form number 2, form number 3 also reveals after 71.
Yes.
Reference is from 71. And notice reveals that
that
coming
is
after
clear, that
70.
is after 25/03/1971.
Now, my lord,
No, it is possible, Mr. Pai, when the tribunal.
Yes.
Initially, during the first phase of inquiry, whether he is a foreigner of which stream, it can be ascertained only by the tribunal.
tribunal.
It may so happen that in the inquiry, it may see that it is from that stream of 1966 to 71. But if the procedure fails to place anything, it
Yes.
may be possible to show, ultimately the tribunal came to a finding that it is after 1971. Possible. So ultimate finding is of the tribunal,
Tribunal.
of which particular
Yes.
period,
That should be based on materials available in the
and it will
record.
be placed by the proceeding
Yes,
before the
yes.
tribunal. But thing is this, here we have seen in a different way, where from the tribunal came to the finding that the proceedings of the stream of 1960 to 71, there is no material there.
No material, no material.
But this is again a writ petition prepared by the proceeding.
Prepared by the proceeding. But my lord, the one thing your lordship will remember, my lord, there was judgment of this honorable court that the tribunal cannot go beyond the reference. That was the initial, my lord, judgment, and that was proceeded and that was accepted by this honorable court for long. Now
But
it has
there
been
is another
explained.
judgment.
Yes, that it
You
has
see-
been explained, further explained. My lord, not only if the reference is bad. In that case, my lord, only the question was if the reference is bad and if it is remanded. In that case, if we remand, my lord, to the referral authority, it should not be remanded only on going through the records of the, my lord, of the my lord, the SP or the, my lord, referring authority. There should be a trial. If in trial it is found that he has come before 71, then there can be, my lord, separate finding on that. That was the issue. Otherwise, my lord, that yes, that is confirmed that you cannot go beyond the reference. The tribunal cannot go beyond the reference. That is certain. But if it has to be remanded on the basis of, my lord, submission material submitted by the, my lord, SP concerned or the ERO, then automatically it may not be remanded. That was the observation in the recent case, my lord. So in that case, Rukia Begum, my lord, there it has been explained. That means it may have been explained to some extent that no, it may not be directly remanded, my lord.
But there is judgment of justice beyond, as he was there.
Yes, there it was.
Where-
There it was said, my lord. There it was said. That is said. The tribunal cannot go beyond the reference. So, if the reference is given by the tribunal SP that he is from 66 to 71, or he is post 71, the tribunal cannot go beyond that. Tribunal has to confirm that whether he has come beyond 71 or in between 66 71. That has to be decided by the tribunal. That is true. Only next question was, my lord, that is not a challenge, or that is not, my lord, the explained. In fact, thereafter, another judgment was there in Ajay Sharma. It was said if the initial reference is bad, my lord, the reference is bad, and the reference is found that it is beyond from the reference document submitted by the SP or ERO, if it is found that initially that the person may not be of 66 to 71 stream or may not be of post 71 stream. So it has been remanded back to the tribunal, to the SP concerned referral authority immediately on receiving of the, my lord, reference, if the tribunal found it so. That was the judgment in the next stage. Then in that case, my lord, this honorable court says no, that is not correct. Let the tribunal, my lord, decide, take the evidence first. If tribunal found that yes, the initial reference was bad, that means the documents which were submitted were not enough, or they may be given opportunity, because, my lord, if the reference is of the reference is made at post 71, initially, the tribunal found that no, it is of 66 to 71. Let them give evidence. No, they are prior to 71, or they may give some evidence in the matter. That was the matter. That is proposition in the Rukia Begum Borgoya. That is latest judgment. Your lordship will find what is there. May read out, madam. The state of Ajay Kumar Sharma. That is in
Rukia Begum number
227921, madam.
22.
79 of 21. And prior to that, your lordship will find 2017 2GLT 1067. This may be recorded, madam.
Which is the other one?
2017 2GLT 1067. That is Santosh Das.
2017.
2GLT 1067. There it is said that tribunal cannot go beyond the reference. So if
Santosh, that is the case where the father deposed on behalf of the daughter or something, I think so.
probably, my lord.
There are
The
two
finding
cases
was
there.
that there it was finding the tribunal would have to confine the terms of the reference made in it and cannot go beyond the same. So whatever term is given by the reference, my lord, tribunal authority, the referral authority, that has to be answered, my lord. The tribunal has to ensure whether he has come beyond 6. My lord, whatever reference is given, that has to be. That cannot go beyond the reference. Now, in this Rukia Begum, my lord, that Santosh Das has not been disturbed.
Santosh Das is 3/4/2017.
2017 2G.
Yes, 3/4/2017.
No.
What is the other one you said?
Other one is, my lord, this is WPC 227921.
Name of the party?
Rukia Begum Borguya. Decided on, my lord, 12/6/2023.
No.
In that case, my lord, your lordship will find para 17.
Which paragraph?
Para 17, my lord, 17. 17 and 18 will do, my lord.
Yes, continue.
The details discussion is in fact from para 12 onwards. The details discussion is there. And the factual aspect is also described in para 12, 13 manner. But I'm reading para 17 manner, that will be minimum. In view of the above, as the principle of per incurium is more applicable, rather than it being principle of stare decisis, this is the principle laid down in paragraph 13 of Ajay Sharma can be ensured accordingly that earlier decision of Phalani BP needs a further clarification to the extent that if the conclusion as regards the faulty reference, if the reference is faulty, that was the question, madam, can be arrived at only upon final decision. It would be the interest of all parties to have the final decision being converted to an opinion rather than to undergo the technicality of returning the reference, having it corrected and decided once again. From such point of view, we are unable to agree with the order that is showing for. So now, in view of just such, to understand, my lord, the entire point, if your lordship kindly see the para 12.
Yes.
On.
Mr. Payang,
My lord.
brother has correctly pointed. We have to follow this. And the tribunal has to refer back the matter to the SP board. Then who in turn shall refer back the matter, saying that the proceedings of this particular city.
Yeah.
Because it is only the final decision of the or the final opinion of the tribunal. The proceeding is found to be of this particular stream. Rightly, wrongly, we are not on that.
Yes.
But the tribunal found that the proceeding is of this particular.
Yes, ma'am.
So the reference was after 25/3/93, on
Yes.
or after 25. So, if with that opinion it is referred back to the Superintendent Police Board, this time the SP boarder either will refer the matter for this particular stream
Yes.
or may not refer. Then it goes in favor of the proceeding. How will get this help? Because you are not a person who you have not challenged this order of the tribunal.
Mr.
No,
Payang, you have referred to para 17.
Yes.
So what is the conclusion in para 17?
Para 17, my lord, what my lord, probably my understanding is this. My lord, if you, for that your lordship have to, my lord, probably I have to read the para 6, 13 and 16, my lord.
Yes.
Because what my reference is that, my lord, the earlier decision in Ajay Das, my lord, Ajay Kumar Sharma, that was, my lord, that if the reference is met by the SP concerned, if he met it is of post 71, and the tribunal found on the very first day that no, the materials whatever given to him is not enough to proceed against him, that he is of post 71, then he has to remand back immediately on the very first day.
Okay.
On the very first day. That was the maladization.
The very first day.
Yes, when
the tribunal has to return that finding.
Return the finding.
Not on materials furnished by the proceeding, because
yes.
on the first day you'll not have the
yes,
or the
but,
evidence.
But on the basis of, my lord, the SP concern.
Yes, on the basis of the report
SP
itself.
concern. Now, in this case, it is said, no. No, you cannot send back. You have to hear the other side.
No, no. Subject to correction, para 17 says
Yes, ma'am.
that that finding of faulty reference comes only at the final decision.
Yes, madam.
Meaning examining the evidences and the materials placed by the proceeding.
Yes, madam.
In that case, for the mere technicality of remanding it back, you can pass the opinion, you can conclude in respect of the stream in which the petitioner is found to be an illegal immigrant.
Yes, ma'am. That has,
So, in the facts of this case, notice was issued and matter
Yep,
was
yep.
matter was referred to for 71.
yes,
Tribunal found that he is not 71.
yes,
So there are two options. Either the matter ends there saying that he is not 71,
yes, ma'am.
which means he is not a foreigner post 70.
Yes,
But tribunal found that he is from 66.
66, 71.
But
But-
if you apply the yardstick of reference,
Yes, ma'am.
then tribunal would not have answered 66. Then the matter would have gone back. If it may not have gone back, tribunal may have simply said reference is answered in negative. End of the story.
That's true, my lord. But, my lord, if your lordship may kindly see para 18 also.
Hmm.
Para 18. In view of the such censure, we are of the view that subsequent order dated so and so would have considered from the another perspective. Although technically, the correct reference would have been maintainable, but
Not
how,
be.
yes,
Would not be maintained.
yes, would not be maintainable. But however, even if earlier decision arrived at the petitioner is a person who entered into the state of Assam from specified territory, on or after 71 is itself a final decision. But the petitioner should deserve an opportunity to assail such final decision on its own merit. If the petitioner is of the view that some further materials are also available and such materials may be produced in the form of additional affidavit, it would also be in the interest of justice to give every opportunity to the petitioner to prove his citizenship. In view of the above and under the circumstance, we also refer with the order dated Chincha Tribunal and allow the petitioner to submit further evidence, additional affidavit, or further materials that he may desire to prove his citizenship. That was the decision. Your Lordship,
So the tribunal's order is not under challenge.
Tribunal order is not under challenge. That is true. My lord, but my lord, the first issue, whether the tribunal can go beyond the reference.
That is what is answered in 17. You pointed out this judgment for everyone's benefit.
We can see from para 13 onwards. I'll go through the para 13 onwards, my lord. There is some issues, my lord.
Mr. Paying, Santosh Das is 2017 2 GLT 1067
1065, madam.
65.
Yes, madam. They are para 16 only. My lord, in this Rukia Begum Borbuya, if your lordship may kindly see para 16 onwards. In fact, this has not said for remanding. Return the reference to the SP. This has said, my lord, whatever the tribunal has decided, there they may be given opportunity to produce their documents. That was the point, madam. Your lordship will find from para 16, madam. Para 16.
Read para 16.
Para 16. The term state disease is defined in the Black Law Dictionary so mean the doctrine of precedent under the court must follow earlier judicial decision when the same point arise again in litigation. We are in complete agreement with the principal precedent and state disease that the court must follow the earlier judicial decision when the same point arise in a litigation. But at the same time, it is also accepted principle of law. The doctrine of par incuriam is an exception to the doctrine of stare decisis. The doctrine of par incuriam is defined to be judicial decision which was wrongly decided because the judge or the judge's will were ill-informed about the applicability of the law. In the instant case, when the decision Falani BB was rendered, the further technical complication that may arise upon a fresh and correct reference being made that it may be barred by principle of res judicata, because res judicata is now applicable, was neither urged upon nor was gone by the court. The question whether the reference is faulty or not can only be determined after there is a decision being rendered that the person concerned entered the state of Assam from this specific territory on or after 25/371. Whereas the referred question was whether he entered the Assam in between 1166 and 25/371. In other words, the conclusion as to whether the reference is faulty or not cannot arrive at only after can arrive can be arrived at only after the final decision has been rendered on the material being produced. And therefore, as a decision had been rendered upon the materials being produced, the same issue, if again referred back with a correction in the wording in the reference, may invoke the principle of res judicata, that it cannot be referred and ensured again, as it would be a subsequent reference on the same issue, which is between the same parties and was decided in a prior proceeding. In the circumstances, we are of the view that the principle of par incurium would be applicable in the instant case rather than the principle of stare decisis. That was the basic question, my lord, whether it can be remanded back in. Then, in that context, my lord, we may read the para 17. Para 17, in view of the above, the principle of par incurium is more applicable rather than it being the principle of stare decisis. The principle laid down in the para 13 of Ajay, thus Ajay Sharma can also be answered in accordingly, and under edition, Phalani Bibi needs to further clarification to the extent that if the conclusion as regards the faulty reference can be arrived at only upon final decision, that is by the tribunal, my lord, it would be the interest of all the parties to have the final decision being converted to an opinion, rather than they undergo the technicality of returning the reference, having it corrected and decided once again. My lord, here, what was the question, my lord, what was the understanding, my understanding? The final decision, my lord, whether the proceeding can be continued or not. That if, my lord, the final decision is given, then will be converted to opinion by taking evidence, enough evidence. That was the understanding. That was understanding. Final decision, yes, my lord, this reference can be continued. Being converted to opinion rather than undergo the technicality of returning the reference, having it corrected and decided once again. From such point of view, we are unable to agree with the order dated so-and-so of the tribunal. That is different. In view of such ensure, we are of the view that subsequent order dated so-and-so would have to be considered from the another perspective. Although technically, the corrected reference would have been maintainable, but however, even if the earlier decision arrived at the petitioner, in this case, there was subsequent proceeding, subsequent reference also after returning. That was the question. But however, even if the earlier decision arrived at petitioner, a person who entered into state of Assam from specified territory on or after 25/3/71, it itself is final decision. So, the present case also, it is a final decision now. It's a final decision, they have taken the decision. But the petitioner also deserves an opportunity to assail such final decision on its merit. So, the petitioner is, if the petitioner is of the view that some further materials are also available and such materials may be produced.
How it will help you? The Phalani Bibi's matter.
Yes.
It was for the stream of 19 January 1962, prior to 25 March 1970. But the tribunal found that no, the proceeding is on or after 25/03/1970.
Now, my lord,
that has become a final
yes,
decision.
this is a final decision. So, if it is a final decision, my submission will be, my lord, whether the material shows that he is entering, my lord, that has to be decided by the tribunal. He is entering from 66/71 or 71. It has to be based on materials available on the record, my lord, whatever evidence they produce. The evidence doesn't say anything that he entered before, my lord, 71.
Let us understand what you are trying to say correctly. If the reference is not as per the order, means thereby that you refer it saying that he belongs to 66 or 71, the material prima facie
yes,
do not support it.
Yes.
Then what is to be done?
No, now, from this decision, my lord.
Earlier,
my lord, that the tribunal could not go beyond that. Tribunal had to confine.
Put up a disagreement note.
Yes, disagreement. Simply saying no.
So, was any disagreement note put up here?
No, that was not here, my lord. So, in the present case, my lord, in the earlier, my lord, that was the point that if he is referred 66/71, the tribunal have to confine only whether he belongs to 66/71 stream or not. If he fails to prove that he belongs, if he, my lord, the later on found, then no, he came 66/71 stream, did not came 67 66, 71. After 71, then also tribunal could not give any opinion against that because the tribunal, the reference was that he is only of 66 to 71. So tribunal could not go beyond that. Now by this, it is said, later on it was in Palani, it was said, if you find initially that there is some fault in the reference, remand back the reference for re-reference. And in the Palani BB, it was re-referred. Re-referred, there it is, that was silenced. Later on, it was silenced. It was silenced. Then it is said, no, that is technicality. That technicality should not be taken because it may cause the res judicata. Because once it was decided, if it is remanded back and if it is again remanded back to the referral authority, it may come under res judicata. So same party, same reference, same issue. So it may cause res judicata. Then it is said the further evidence may be allowed. The decision may be taken by the tribunal on the basis of evidence, whatever given by the them or by the state. Then if it is found that yes, he come not in 66, 71, but after 71, then the reference, even though the letter reference was wrong initially, that may be continued and they may be given enough opportunity, everyone may be given enough opportunity to establish that he is a citizen or he has not come after 71. That is the decision of this matter.
In the facts of this case, how do we apply the?
My submission is, my lord, in the present case, first of all, my lord, the decision of this honorable court says my lord, evidence, materials, whatever given by the materials available in the record, that has to be examined. There, from the materials, we have not seen anything that my lord, he has entered in between 66, 71.
See, this is the reference, this order is not under challenge.
Yes, that is not under challenge. That is not under challenge. But my lord,
State is
now,
not agree, it has not filed anything yet.
my lord, simply now, if your lordship directs for registration also, that we have to see whether registration can be done on the basis of these findings, my lord. Without any basis of, my lord, without any basis. In certiorari, my lord,
Mr. Kolita, would you like to offer some assistance matter to the court?
Yes, Lordship, yes.
A very peculiar situation.
Yes, sir.
There was a reference made saying that he is
71.
71.
Yes.
Tribunal decided the matter and said he is 66. And issued a direction to the executive magistrate,
Lordship.
a district magistrate, isn't it?
Yes.
District magistrate. District magistrate said, when they went saying that we are not the authority, it is FRRO. They went to FRRO, FRRO said there is no direction for us, we can't do it. Therefore, this court. Mr. Payne, during his submissions, has placed certain judgment. Now, one of the judgments says that where there is apparently a wrong reference, not wrong, or a
Beyond
reference
reference.
which the tribunal feels is not correct. Ordinarily, you send it back with a disagreement. But where it appears that you have to delve into the matter, then you have to give the other side opportunity, evidence or whatever, then fine. And then if you see that, yes, the evidence does not tally with the reference page, then what is the step? This judgment says that in that case, after having heard this part, examine the document. Only for a technical ground of remanding it back, don't do it. You render the opinion. So whether this judgment was followed, not followed, we don't know. But in principle, tribunal rendered the opinion that they are 1966. So now the question is, what is the law? Because earlier law was disagreement because there is a jurisdiction of the tribunal. Tribunal jurisdiction is with regard to the reference made.
Absolutely.
So the documents on records reveal that the reference is for 971. So tribunal could have either agreed or disagreed.
Or disagreed, yes.
Matter would have ended there.
Correct, Lord.
But tribunal did not do that. Tribunal said 66, which in a sense means the reference was answered in negative,
Negative.
but something more was said.
Correct.
And this petition is filed by the petitioner seeking implementation of that order. This tribunal's order is not under challenge.
Correct, Lord.
So we request you to examine the matter and
do it,
the procedure,
I'll do it, Lord, sir.
as well as the records which are available.
Yes.
And then tell us,
I'll try to assist you, Lord.
we have something in our mind, but we are waiting for some submissions to come from the council at the bar, both councils. Whether, depending on what submissions come, we'll disclose what is there in our mind.
Lord, I will do my best to assist you.
Mr. Biswas and Mr. San will keep it for next week, let them file.
Lord,
Because,
yes, you have got no objection. Lord. Whatever is,
because it appears to have two contradictory views of precedents.
It's a kind of a peculiar situation, like peculiar. So we'll go through it, Lord. So we'll assist you, Lord.
It has become more peculiar by virtue of the fact that the state is not even before the court challenging.
Yes, yes. Yes,
it is the only embargo. My Lord. State has not preferred any appeal against the judgment.
Sorry,
State has not preferred any appeal against the
that's
judgment.
what I said.
That is the only
It
embargo.
was not challenged.
Exactly. And your prayer in the writ petition is not for setting aside.
Yes.
Yes,
It
not,
is
not
for implementing.
They implement, they want to register.
registered, and the order was technically mistaken by the member. My Lord. He has forwarded me to district magistrate.
You would have filed a review.
Instead of that, we have come here.
No,
Yes, we could have filed a review, my Lord, there.
We wanted to know whether at the relevant point of time, was the district magistrate the authority?
No, no, no,
Yes,
never,
yes,
never.
it was never.
It is always there.
It was always a
Anyway, that, we'll take it up on sometime next week as per your convenience.
Yes, Lord, next week.
Obligement.
Next week, Lord.
And regarding registration, there are lots of judgment of this Honorable High Court. My Lord, he is also, was
You
also.
cannot- you give us all the judgment.
Yes, we
whatever.
shall give.
Heard, learned counsels appearing for the parties.
Evidence or not further evidence.
The issue before this court is the order opinion dated so and so passed by so and so 30. 9/8/2016. Whereby opinion dated 9/8/2016 passed in FT number 8, FT within bracket 8, case number 178 of 2015 by the learned member, Foreigners Tribunal within bracket 8, Sonitpur, Elamara. So, by the said order, the petitioner, the tribunal answered the reference in affirmative, holding, but holding that the petitioner is an illegal migrant who has entered Assam between 1/1/1996 and 24/03/1971. Stop. The petitioner was directed to register herself in accordance with Rule 19 of the Citizenship Rules 2009 before the competent authority within bracket district magistrate within 30 days of the order thereof. Stop. Better. The petitioner is before this court seeking appropriate orders as the authority named in the opinion/order of the tribunal, namely the district magistrate, upon being approached pursuant to the directions contained in the said order, refused to register the name of the petitioner on the ground that the said authority, namely the district magistrate, is not the competent authority under the act/rules. Stop. It was informed that the competent authority is FRRO. What is the full form?
Foreigner Regional Registration Officer.
Foreigners
Regional registration.
Foreigners Regional Registration Office, in bracket FRR. Stop. The petitioner thereafter approached the office of the FRRO, who in turn also refused to register the petitioner in terms of the order dated so and so, passed by the Foreigners Tribunal, on the ground that the order does not issue any direction to the FRRO to register the petition. Stop. Being faced with such a dilemma, the petitioner has approached his court praying for appropriate direction. During the course of the hearing, and upon examination of the records called for from the tribunal, it is seen that the reference was made by the local authority to the tribunal to render an opinion whether the petitioner is a foreigner/illegal migrant who had entered Assam from the specified territory post 25/03/1971. Stop. Mr. Payeng, learned counsel representing the Home Department, has referred to judgments passed by coordinate benches to submit that the tribunal's jurisdiction tribunal's power to render opinion is in only in respect of the references made. So he submits that the reference made by the concerned authorities to the tribunal was to render an opinion as to whether the petitioner was an illegal migrant from the specified territory who had entered Assam illegally post 25/3/1971. So, but the tribunal answered the reference in affirmative, However, held that the tribunal is an illegal migrant who had entered Assam between 1/1/1966 to 24/3/1971. So, it therefore submits that the tribunal rendered this opinion, which was beyond the terms of the reference, and therefore no relief can be granted or ought to be granted. In this context, the counsel for the petitioner for the reference, for the respondent, refers to which judgment?
2000
Santosh Das.
Santosh Das.
Santosh Das reported in
2017 to DLT 1065.
2017
to
to DLT 1065, as well as Rukia Begum or Bia, reported in 2023 within brackets 0 Supreme bracket DAU bracket close 568. Decided on 12/6/2020. So, a perusal of these two judgments reveal that there appears to be two contrary views arrived at by the coordinate benches, both the coordinate benches, while rendering these two judgments. So, under these circumstances, we request the assistance of Mr. Panjan M. Kolita.
I'm already there, Lordship. I'm also a standing
You are
counsel.
also there.
Standing counsel.
Request the assistance of the councils for the state, both Mr. Kolita and Mr. Pai, as well as Mr. Sharma, to assist the court and apprise the court of the various judgments rendered by coordinate benches on this aspect. So, the petitioner's counsel, Mr. Discourse, is also permitted to place before the court the judgments he seeks to rely. Let the matter be listed again on 24th.
Next Tuesday?
On 24th of September. So, the counsels for the parties are permitted to peruse the trial court record in the presence of the court. Please record.
Published.
Motion to move করবো ক্ষমতা Mr. Sharma, Mr. Pang, are you aware of these councils? Pranjal Sharma, Shankar Das, Pavitra Honwal.
I know one Pranjal Sharma, but whether
This matter was, notice was issued in a, when there was none for the petition. Bail was also granted at that point of time. Now, on last occasion, when the matter was taken up for consideration on December 2021.
we can make an inquiry to Mother P. Sharma because we have But otherwise, we don't.
But this is Pranjal Sharma, huh?
Yes, Pranjal Sharma.
Pranjal Sharma, Uday Shankar Das, Pavitra Sonowal. There is no document on behalf of the proceeding to prove her link with her father. That's what the judgment says. Though her father was alive, her brothers were alive. So that's how the proceeding says. Records are available. No representation on behalf of the petitioner. On call.
My lord,
Pranjal Sharma, I know Pranjal Sharma Lordship. He is at Delhi Lordship. He is at Delhi Lordship at present. Lordship. He asked me to kindly fix the matter after Puja vacation Lordship.
To name of three councils happened. To negate the name of the petition. Because the proceeding against the petitioner was of 1997. The impugned opinion declaring the petitioner as a foreigner of post 25/03/1970 was of 15/06/2016. Said petition was filed by her on 30/01/2018. The petitioner is an interim protection and bail since February 2008. Registry has also received the relevant records from the concerned Governors Tribunal, Morrigan. Place this matter for hearing again on 24/10.